Good afternoon. My name is Deb Van Dyke Reese, and I'm the director of the Nebraska Court Improvement Project. And I'd like to welcome you to today's CIP legislative preview. It's my honor to have such an esteemed group of panelists to share their insight into legislation for this particular session. Before we jump into the webinar, I wanted to do some housekeeping items. First of all, this legislative webinar is being recorded and will be available on the CIP website in the next week or so. All of the participants have been muted and cameras are off. Panelists will have their cameras on. But if you do have questions for any of the panelists, we ask you to put those into the chat, and then we will continue to monitor that for any questions that may come up. We also are wanting to let you know that the activity code for CLEs will be provided at the end of this legislative preview webinar. So with that, I'm going to ask for the next slide to be advanced so I can just give a preview of what is CIP. So the Nebraska Court Improvement Project is housed within the administrative offices of courts and probation. We actually have federal funds to help support our child welfare work. And a key piece, a cornerstone of our work are our multidisciplinary Through the Eyes of the Child teams. We do have a team in every single county, and each of these teams are led by juvenile court judges or county court judges with juvenile court jurisdiction who look at issues on a local level. And then those teams, those multidisciplinary teams, come together to then identify solutions. Part of what we do at CIP is to help support those teams, but then also provide data and research to help move the particular team's goals forward. A key piece of what we do too is education. So such as these webinars, we host the Children's Summit every 3 years and regional conferences on those off years. And in the next month or so, you will be finding information coming out about our upcoming regional conferences and then our lecture series for later in the year. So with that, I'm going to turn it over to Teresa Cusick, who is a project specialist for the Court Improvement Project, to introduce our speakers and get the webinar started. Thank you.
Hi, everyone. I'm going to start today off by giving just a general overview of the lawmaking process in Nebraska. So we have a unicameral legislature, so one house, which traditionally simplifies the process a bit. Bills are introduced in the first 10 days of the session, and each bill gets a fiscal note to estimate the state, county, and or municipal cost of any changes. And then each bill is referenced to a committee. And every bill gets a public hearing where folks can come and testify as proponents, opponents, or in a neutral capacity on the bill. And after the hearing, the committee then can vote to send the bill to general file with or without any amendments. They can indefinitely postpone the bill, or they could just take no action on the bill. Now, general file is the first time that the full legislature has a chance to debate and vote on the bill and then any additional amendments. And it takes 25 votes to adopt amendments and move the bill on from general file. The next stage is called enrollment and review, and this is where any amendments that have been made are incorporated and then checks for grammar. The next step is select file, and that is the second round of debate and voting. And this is another opportunity where amendments can be proposed to the bill. And at this stage, the bill can be voted forward, can be amended, or it again can be postponed. After that, we've got another E&R round, enrollment and review. And that is followed by a final reading. And this is when the bill is read aloud by the clerk, unless that requirement is waived by a vote of 30. And a bill at this stage can't be amended, but it could be resent to select file. And a majority vote at this point is required before the bill can be sent on to the governor. And that's unless the bill has an emergency clause, which then requires 33 votes. So after the legislature passes a bill on final reading, it goes to the governor for consideration. And the governor has 5 days, excluding Sundays, to decide what to do with the bill. So that could include signing the bill, line item vetoing the bill, or just vetoing the bill altogether. And the legislature at this point can override a veto, although it takes a vote of 30 senators to do so. And most bills that are passed and approved by the governor become law 3 months after the legislature concludes or adjourns, unless there's an emergency clause with a specific date in which the bill will be enacted. So I am going to send it over to our first presenter for today, which will be Dennis Marks. If you want to get his slides going. And Dennis Marks is a deputy public defender in Sarpy County. Welcome, Dennis. Thank you for being here.
Thanks. Thanks for having me. I'm going to talk about 3 LBs. The first one being LB 30 with the no contest provision being available on the delinquency side. Not a huge fan. That may surprise many of you that a public defender takes a position like that, but I think no contest is an adult concept. I'm fine with it being in the child welfare side with adults, and definitely fine with it being in county court and district court because it has merit and it has a purpose in those particular jurisdictions. I don't think it has any useful use anyway in juvenile court on the delinquency side. No contest is maybe I did, maybe I didn't. I prefer my clients to pick a side. I do not want to have to go through the course of probation listening to a client say, why do I have to do this? I didn't do anything. So my preference actually is I'd rather set it for trial and lose than not have a factual basis from a client, or have a client who says I didn't do it. So that's my thoughts on LB 30. I think it's more appropriate on the adult side. I also looked at LB 76, which I kind of find to be kind of interesting, and I'm not a fan of that one either. This is the provision, and it's pretty well set forth in the description that talks about, when a juvenile judge orders an electronic monitor, they have 2 choices. In the written order, they can allow data from the electronic monitor from the agency to be released immediately upon request by law enforcement. Their other choice is just to remain silent and not address that particular provision. And my thought is it's probably going to get added to an order more often than not. I think template language is just going to be added, and it's just going to be part of the order as an afterthought or as no thought. And I think that's a mistake. Law enforcement can get that information now. They just have to get a warrant. And to get a warrant, it's not a high hurdle. They just got to show probable cause. And it doesn't take that long. I think about some of the police reports that I've read over the years where there's an MIP party and the occupants in the house will not let law enforcement in. Law enforcement, establishes a perimeter, and then they go see a judge and they get a warrant, and then they knock on that door, they show the warrant, and then they're allowed entry. I just think that judges have a gatekeeping responsibility, a constitutional gatekeeping responsibility to look at affidavits that law enforcement might draft in order to get this information. It's a constitutional safeguard, and I don't think that this particular constitutional state or safeguard should be abdicated for the sake of convenience. Get your warrant. I've had other instances where I've got juveniles who are detained, alleged to have violated the law, and then they get charged as adults. And then the adult judge looking at the PC affidavit finds no PC. So it's not a high hurdle, but it's a hurdle nonetheless that I think law enforcement should undertake in order to get that information. So, and then the last bill that I was going to talk about had to do with the use of deception by law enforcement when investigating a crime. I'm a fan of this particular bill. Deception, the bill goes ahead and defines deception. It's one of two ways. Either law enforcement is intentionally and knowingly communicating false facts concerning the evidence of a case, or they're representing or communicating false facts, false information, false statements to a juvenile concerning leniency in an arrest, leniency in prosecution, or leniency at the disposition. And communication is also defined in there, which I think is good. The devil is always in the details. So communication can be verbal, it could be written, or it could be provided in sign language. And if deception is used by law enforcement, then any statement or admission would be inadmissible. So, when I read this bill, I just thought of Lenny Briscoe and Law and Order. So I don't think we need this, or I would like to see this bill passed, because we don't need law enforcement using deception with our youth. They're underdeveloped. Their brain is still developing. They are not that sophisticated. And they can be pretty stupid in some of the acts that they do in violation of the law. I just think that when they interview them, if they use deception and then ultimately the youth finds out, the adolescent is going to develop and does develop a mistrust of law enforcement, which I don't think is a good thing. They also, that distrust kind of leaches into the entire justice system. So they really have a distrust of any justice stakeholders, like their public defender, their defense attorney. They don't trust the prosecutor. They don't trust the judge, a probation officer. And sometimes that mistrust can also leach into their parents, because, at least it's not uncommon for parents, at least parents who aren't public defenders, to tell their children, that, hey, you can trust law enforcement. They're there to do the right thing. It's not necessary. I always, when I'm looking at juveniles and issues or concerns that come up in juvenile court, I always like to put on the adolescent development glasses. And adolescents at this particular age have a keen sense of justice and fairness. So when law enforcement lies to them, that sense of fairness and justice is violated, and it doesn't go away, and it can impact a lot of authority figures for that youth going forward. So those are my thoughts on these three bills.
Perfect. We appreciate that. We will send it to our next presenter from the separate Juvenile Court of Douglas County, Judge Stevens. Thank you for being here.
Thank you for the PowerPoint. All right. Get ready for a fire hose, maybe, presentation from me. I'll be presenting on LB 339 and LB 717. And LB 339 was originally presented by Senator McKinney and has since been joined by Senator Hunt. And it's kind of a kitchen sink juvenile law related bill. So I'm going to try and summarize pieces of it for you. And as a judge, I won't have any positions on things, but I can answer questions and give information. So love to hear feedback on this one. So LB 339 has several sections to it. The first actually creates new legislation indicating that any criminal prosecution of a person who is under the age of 18 years when the alleged offense was committed shall be conducted in such a manner as to maintain confidentiality of the identity of the defendant, and then sets out court procedures for release of information that would otherwise be considered confidential, and sets out those parties to whom it can be released. So this is in relation to criminal prosecution as opposed to juvenile prosecution. Information that would otherwise be confidential under this statute could be released to persons providing services for the defendant, and this is a defendant under the age of 18, could be provided to the court. Confidential information could be provided to the Office of Public Counsel and Inspector General for Child Welfare, as well as the Inspector General for the Nebraska Correctional System. It could be provided to persons as requested by the defendant. It could be provided to law enforcement, the county attorney, and the city attorney. So everybody on law enforcement and prosecution under that umbrella could be provided to the Nebraska Probation System, Department of Correctional Services, a jail, or any other detention facility as necessary, specifically for the custody and care of the defendant. It could be provided to DHHS or a contracting facility when the defendant is undergoing a competency evaluation and or restoration of competency, and could be conducted to those conducting bona fide research with the permission of the state court administrator's office. This new legislation imposes an obligation to maintain the confidentiality of the information they receive on those who receive it, similar to how the juvenile statutes function, and does not apply to the pre-sentence investigation reports. So that's been excluded. The legislation also specifically indicates that nothing in this section would be construed to restrict dissemination of information about a defendant who is a fugitive from justice or otherwise missing. That's the first section. Then the legislation proposes to amend 28501 as it relates to the death penalty or life imprisonment in certain circumstances. And the legislation proposed states that a death penalty or life imprisonment shall not be imposed on any person who was under the age of 22 years when the offense was committed. The legislation also instructs for mandatory sentencing, indicating that the maximum sentence for a Class 1B felony committed by a person when committed and the person was under the age of 22 shall not be greater than 60 years, and a minimum sentence of not greater than 20 years, except as already provided in 28319.01. And for purposes of preparation here, I did not go look at that. Sorry about that, but I didn't go any further. Dennis, do you have anything to add in regard to that?
I don't, Peg.
Okay.
Not yet, anyway. This is such a huge bill with so many pieces, so many moving pieces, that I appreciate your taking this particular bill on. There's a lot to chew on here.
There is. All right. Next, the bill proposes that Section 29401 be amended to state the following. The court in which a juvenile is to appear shall not accept a plea from the juvenile until finding. And as a judge, I interpret that to be imposing an obligation on the court to make a specific finding that the parent, guardian, or custodian of the juvenile has been notified of the arrest and filing of petition, is what they're referring to, or that reasonable efforts to notify the parent, guardian, or custodian of such person has been made. All right, I have nothing to say. The next one, it is a section of new legislation that's being proposed for the criminal code. The legislation being proposed directs that defines the status of a young adult in criminal prosecution. It's defined as a person who is 18 years of age or older and younger than 22 years of age. Then there are subsections in regard to that direct specific things. First, for law enforcement who take a young adult into custody. So a young adult is somebody between 18 and 22, shall inform the young adult using developmentally appropriate language and without unnecessary delay. Shall inform the young adult of the right to consult an attorney and permit the young adult to call or consult an attorney without delay. The attorney shall be permitted to meet with the young adult alone or in private, basically as soon as they arrive. The statute also sets forth specific developmentally appropriate language to be used by law enforcement when advising of rights. Right now, nothing like that is contained in the criminal code or the juvenile code, that being specific developmentally appropriate phrases and explanation phrases. This statute sets them out with specificity. And later, the same language it's proposed to be implemented in the juvenile code. The next subsection instructs that law enforcement shall immediately take responsibility. Strike that. Shall immediately take reasonable measures to notify the young adult's parent, guardian, or custodian that that child has been taken into custody. Interrogation will cease if the young adult requests to speak with a parent or guardian or custodian. And that's just black and white. So even if law enforcement has not reached a parent, even if law enforcement hasn't taken any reasonable measures yet, if a child requests to speak with their parent, any interrogation or questioning or conversation that might be going on with the child has to stop. If the parent arrives, they shall be allowed to meet the young adult without unnecessary delay. Except there's one exception. This does not apply if there's reason to believe the parent has been involved in a crime related to that for which the juvenile is suspected, taken into custody, going to be questioned about. And any statement of the young adult gained in violation of this statute shall not be admissible against them in court. Next, the legislative bill proposes to amend section 292204. It's amended to apply to sentencing of those individuals who are 22 or older at the time the crime was committed. So I'm not going to go into that any further. I don't think we need to, but that's the purpose of it. There is an proposed amendment to 43245 to define the age of majority specifically as 19 years or 22 years of age for a person who has been adjudicated in juvenile court for a class 1A or 1B felony. So it would extend the age of majority as it applies to juvenile court jurisdiction to persons who are between up to 22 years of age, if that person has been adjudicated for a class 1A or class 1B felony. It also defines juvenile as any person under the age of 18 or under the age of 22 who's been adjudicated in juvenile court for either of those two felonies. The legislative bill also proposes amendment of 4324.248.01 and 250 and 253 to mirror the language that we reviewed first in relation to specific language to be used by law enforcement in a rights advisory before there can be a custodial interrogation. And the amendments also remove superfluous language that doesn't need to be there anymore because it refers to what should happen before 2013 and what should happen after 2013 or 2016 or whatever it is. The legislation proposes new statute that directs NDHHS to use day reporting and evening reporting centers as appropriate for youth in their custody, and delineates other specific regulations for that purpose underneath it. New statute that would indicate a juvenile adjudicated under the code shall not be transferred out of state except in a medical emergency or for necessary mental health treatment. And I could not find any history, any statements on the record by the proponents of the bill, anything to explain that further. So I'm not sure what they mean by shall not be transferred out of the state. Also, the legislative bill proposes a new statute that creates the same confidentiality regulations for adjudications under the juvenile code, and adds DHHS as an agency to have access to confidential information. It proposes new legislation that instructs DHHS to establish a family resource and family resource and juvenile assessment center pilot program for cities of the metropolitan class, and it to be funded so that it can be open 24/7. A family resource and juvenile assessment center, all of the activities and things involved in that are laid out, but let me summarize for you really quick. Lost my page. There it is. Is to provide resources to at-risk youth to prevent incarceration and minimize individual and community harm by keeping youth from becoming more involved in the juvenile justice system. The center is considered preventative in nature. It's supposed to house multiple community providers under one roof for the convenience of families and provide assessment services to youth and families to address immediate ongoing needs. There's supposed to be no charge to assessments for families. The centers are to be able to provide connections to a comprehensive array of services, including tutoring, mentoring, drug and substance abuse education and intervention, conflict resolution, mental health services and support, anger management, social skills training, job skills development, financial literacy, individual and family therapy sessions, cognitive behavioral health, truancy prevention, parenting skills, food and clothing assistance, and referrals to court diversion programs. So that would be a huge undertaking. Very quickly, I'll review LB 717 with you. That was presented by Justice Kavanaugh, and in nature, the tenor of it is similar to LB 339, but distinguishable in that Senator Kavanaugh proposes to change the age of majority to 19 years of age or 25 years of age for a person who is adjudicated for a violation of Section 28303 or 304, and to change the definition of a juvenile to a person who's under the age of 25 if such person was adjudicated for violation of 28303 or 304, and to amend 4346.01, indicating that the juvenile court shall have exclusive original jurisdiction to any juvenile who is under 14 years of age at the time an alleged offense was committed, and the offense falls under Section 28303 and 28304. Did I make it under 10 minutes?
More or less, yes. Thank you so much, especially for breaking down LB 339. That's a lot of components to it. So thank you. Our next presenter is Bree McClarty, and she is a deputy county attorney in Dodge County. Welcome, Bree.
Thank you. Sorry, I was late. And I appreciate Judge Stevens taking the heavy work of breaking down 339, so I can just jump into it when it's time to get there. So I'm going to talk about 4 bills. A lot of them have already been covered, so I'm really going to kind of talk a little bit about how this would work in practice if it were passed, or kind of some things I flagged as questions that still need to be answered. So, for example, with LB 184, this really is talking about, like it says, the inadmissibility of statements made at what's called a transfer hearing. So there are some situations where a juvenile court and a county court have court concurrent jurisdiction. So the county attorney can choose to file either in juvenile court or in adult, and then a transfer motion could be made. I'll be honest, if the county attorney's filing in adult court, we're not the ones making the transfer motion. It's someone like Dennis doing it. If it's in juvenile court, we as county attorneys can file in juvenile and at the same time file a motion to move it up to adult court. So what we're talking about with the inadmissibility of statements in the LB 184 is pretty much saying, if the juvenile were to testify, or if there were going to be a mental health provider or another expert that would testify about why it should be moved or not. So when you're talking about moving from juvenile to adult or adult to juvenile, the question really is there anything left the juvenile court can offer that would justify that juvenile staying in the juvenile court system? So we're really looking at, have we exhausted all efforts? So for example, if we're talking about a mental health provider, they might come in and say, this person, needs this particular service, or they haven't tried the service that would be beneficial. So something like multi-systemic therapy, or something that we would offer in the juvenile court system. The issue I flagged in this bill specifically is, if you're talking about, and how this bill is written is, that person making a statement, either the juvenile making the statement to a mental health expert or person, that in the bill it says it cannot be used in any further proceedings. And I get why. I understand what Senator Kavanaugh's trying to do. He's trying to make it so that the juvenile, in advocating for themselves to stay in juvenile court or to be transferred to juvenile court, that they should be able to speak freely about their willingness to participate in the service, about what services they feel would be appropriate for them. You don't want to use that later and say, well, haha, you said you did it. So I get why he's doing it, but with that really broad language, we're now talking about how if that kid were to have gotten, say, a psychological evaluation that recommended a specific treatment, saying that we can't use that juvenile statement or that mental health expert's opinion that came from that statement, we can't use it in any further proceeding. That means we can't use it at disposition, which is where we're going to recommend the service in juvenile court. So that's just, I think, maybe an unintended consequence of the bill, and something we need to think about when we're using that type of language of any proceeding. Is now we're talking about, we are now going to have a delay in services because we have to go get a new psychological evaluation that's not tainted by that juvenile statements for the purposes of the motion to transfer hearing. So it's a really wonky thing to describe, but it's just something we flagged as, I don't think it was an intended consequence to delay services if the court were to determine that juvenile court was the best place for this juvenile to be to receive services. So that's 184. 339, Judge Stevens, like I said, did a lot of the heavy lifting in what was being talked about in that bill. And it is an omnibus bill. There's everything in here. So I'm going to talk about some things I like, because I feel like I usually kind of get grumpy about some of the bills. So one of the things I love is the concept of a pilot program for a juvenile assessment center. We have seen some of the larger counties really play with this idea and kind of try to cobble together and build it while they're doing it. So like in Omaha, for example, we have the Juvenile Assessment Center, the JAC, and they do a lot of the screenings for like that pretrial diversion, what appropriate services can be. If I have kids that, get an MIP up here in Fremont, we'll transfer it to the JEC for that. We'll put them in diversion here, and then they kind of send it to the JAC to decide if it's appropriate for them to continue on with diversion versus not. So it's a great service. And then you look at what's happening in Lincoln and what they've just kind of started working on in the last 2 years with the Cedars program. They have a 24-hour kind of shelter and emergency where when probation intakes happen, and I think when 3A removals happen, they'll go to Cedars as kind of that shelter wraparound service. They have a couple of nonprofits there to help offer therapy, counseling, a fast track for evaluations. So some of the bigger counties are really playing with this idea. And the concept of a pilot program is great. We've seen how HHS can utilize this pilot program structure to implement new programs like the alternative response. My only issue with it is he limits it to cities of first metropolitan class, which is 400,000. And as someone who lives in a city of 25,000 who would absolutely love this type of service in our community, I'm kind of like, no, let the rest of us have it too. So I'd love to see that kind of clarification or that classification go away and allow HHS to look at a pilot program in multiple communities to see if it can work in small communities like mine, where we do work collaboratively together, but it would be nice if it was in one space, especially as these local communities like my own are looking at rehauling their justice center or their court systems, because we've outgrown our very tiny 1890s space. So we are looking at investing local money in building these type of buildings and infrastructures. So to have this pilot program where the programming can come with funding from HHS would be a catalyst. It'd be a huge game changer. Another thing to note is it directs HHS to do that, but I really feel like it should also incorporate probation as part of that, like he does in another section when he's talking about the day and evening reporting. He's directing both HHS and probation to come together to work on that. So juveniles being served under the juvenile court can go to these day and evening reporting. I'd like to see that type of marriage again with this JAC, because if we're talking about pretrial diversion, you are kind of having an eye about the juvenile delinquency side of cases. And if we're going to do wraparound services for the family and the juveniles, it would be nice if both of the state agencies could come together and work on that. Because I think all of us that work in this area recognize that it's not just a silo. It's not just the juvenile and it's not just the parents. When you're talking about 3A cases, it really is the family as a whole. And if we're going to have these assessment centers and family resource centers, I think both state agencies that serve families, if they were to get to juvenile court, should have some buy-in when it comes to the prevention of them even entering the system. So those are just some of the big takeaways on 339. There's so much in there. The one thing I did want to flag last of 339 is those custodial interrogations. Dennis did a great job kind of explaining how the public defenders work with that and what they kind of see from the juvenile defendant side. The only thing I wanted to flag is there's a lingering question about how that would impact probation intakes that are done after juvenile is taken into custody. One of the ways, once a juvenile is taken into custody, one of the possible outcomes would be to then be handed over to probation for an intake to assess safety and whether the kid can go home without restriction, home with an EM, shelter care, or detention. And this is a lot different than what we see on an adult side, where it's you're released with a citation or you go to jail. There's no assessment about safety unless it's a mental health board of mental health situation. But in juveniles, we have that kind of gray area. So looking at is there any unintended ramifications of those custodial interrogations restrictions as it relates to then probation doing that safety assessment and going forward in that way? I don't really have a good answer for that. It's just something that popped into my head when I was reading it, and I'm definitely going to talk to Senator McKinney about it and see kind of how that would play out. LB 717, we've seen actually quite a few quite a few bills this session that really are playing with the idea of jurisdiction as it relates to age. I know Judge Stevens already talked about this in 339 and in 717. There's also a lot about juvenile sentencing, especially for some of those higher felonies. And I really think with 717, this is an interesting response to what I think Senator Kavanaugh is hearing from his county attorney and what they're seeing in Omaha. Right now, the concurrent jurisdiction I talked about earlier of juveniles that can be charged as adults are really limited to those higher felonies. We're talking murders, class 1 and class 2 felonies, and then they have to be over the age of 16 to be done in adult court. But we're seeing in the Omaha area, juveniles as young as 14 and 13 that are involved in gang activity being the ones that are tasked with taking out and executing these hits. And so now we have 13-year-olds that are committing murder, for lack of a better term. And so I think he's trying to balance that, where he's allowing a lowering of age to be able to be tried as an adult, but trying to make the argument that by given more time in the juvenile court system, that rehabilitative service is still available. Because that's what we've heard is, some of these kids, when they're 16 or 17 and they're committing these class 1 or 2 felonies, well, there's only 2 years of the juvenile court jurisdiction. What's the point? Like, there's not enough time for the service. So I think Senator Kavanaugh's trying to split the difference, giving the county attorney in Douglas County a little bit more leeway, but then also saying, but you have a longer runway that you can provide services. And it's a great question to ask about what Dennis said earlier is we're talking about brain development. We're talking about where kids are in that frontal cortex and problem solving development. And I don't know there's ever going to be a perfect solution. But I think those bills we see with 339 and 717 are senators really trying to grapple with what we're seeing in the community that are public safety threats, but recognizing where juveniles are in their emotional and intellectual development. So that's just some of my thoughts on 717. And the last one is, I feel like I talk about this every year, is LB 507. It's the truancy bill. This one is a kind of a riff on what Senator Pansy Brooks offered last year. Senator Conrad added a few new things to it. I've had some great conversations with Senator Conrad about it. And really, the sticking point from a county attorney side is just the complete absolvement of jurisdiction for truancy. I think we can all agree with those of us that work in the juvenile court. There are some families and cases that get caught up in the juvenile court system that don't need to be there. I've floated the idea of narrowing the definition. So it really is just truancy, and trying to narrow the definition so much that the schools don't count things as truant absences that aren't, giving some direction to county attorneys about what really can go to juvenile court and what should go to juvenile court, and a juvenile delinquency mindset. But then, God love her, she's given millions of dollars to the community-based aid grant to try and help us do that prevention. One of the biggest things is lowering the age demographic. Right now, that grant is limited to prevention of juvenile delinquency cases in the court system. So we're limited in those funds to only being able to serve kids that are 11 or older. By eliminating that 11-year mark, we can now do prevention services for juveniles in the elementary and middle school, where we really see those truancy issues or absenteeism really start happening. So it's a great, again, trying to balance the two. I would strongly advocate for keeping the jurisdiction as that last resort, and just something to kind of throw out there, if it were to go with the elimination of the truancy jurisdiction in general. We only have so much money, and we have so many things we're trying to help and work on in our community. If you're going to tell county attorneys you can't file on truancy cases, but then you have to go and do all this extra work to prevent truancy cases you can't file, but here's a big pot of money, do with it what you want to prevent kids from entering the court system, we're going to look at and reinvesting that money not in truancy programs that we have currently, because if that's not ever going to go to court, we're going to look at that money and try and fund things for mental health crisis and spend our money in a different way to really prevent those that could actually, by jurisdiction, go to the court system. So I think there's a difficultness of, I guess, the tail wagging the dog, that if you take away our jurisdiction, we're going to just spend that money on other things that we still have jurisdiction over to prevent them going into the court system. But that's just kind of some of the bills that I flagged from the county attorney side that we're looking at what they'd look like implemented. I know this isn't on the list, but we talked about it last year. LB 932, Senator Hunt's bill about the Social Security benefits, that went into effect. So those of you that are garden out items and go into the court system, make sure that sheet is on the back of your case plan. If a kid is receiving Social Security benefits, that needs to be included in the case plan and the reports to the court on a biannual basis. And if you're garden ad litem, they need to be telling you the second that they get that checking account open and that first check is deposited. So little carryover from last year, but I just started getting them attached to my case plan. Very happy that it's happening. So I just want to give everyone a heads up to start looking for that.
It's great. Thank you so much, Bree. It's great to hear your thoughts on some of the real practical applications of some of these bills. I'm going to now introduce our next presenter. Elizabeth Einen Kogerda is the managing attorney at Education Rights Council. Welcome.
Hi, thank you. Education Rights Council works with a lot of kids that are in the juvenile system, trying to address the educational pieces that impact their ability to get out of the system. The first bill I've been asked to discuss is LB 231, that requires services to address barriers to attendance to be provided. Right now in the statute, it says that a school district has to have, quote, an attendance plan before they refer something for truancy. The challenge is the way school districts do this is like at 5 days, they send them a note, 10 days, they send them a list, 15 days, they say, hey, it's going to be troublesome. And then on the 20th day, they say that was our plan, and they refer them for truancy. So they don't really necessarily do a plan. This asks them to do more of a plan that after the first stuff hasn't worked. And the other thing it asks them to do is to make sure that part of that collaborative plan is an evaluation to determine whether there are any intellectual, academic, or social emotional barriers that are contributing. So in other words, we too often see children come into the system and it turns out they have ASD, anxiety, some other unmet need that's the obligation of the school district to address, which is the underlying cause for their truancy. So this would be a methodology to say, kind of similar to what Bree was just talking about. Hey, let's do something in addition. Let's make sure the school has crossed its T's and dotted its I's before we say it's just a truancy issue. In case it's instead a child find or special education issue, we should address before calling it pure truancy. I have a lot of bills, so I am just going to zip along. The next bill obviously is 339, and thank goodness that Judge Stevens and Dennis and Bree went through it all. The only thing I want to draw people's attention to, and I'm interested in like your input on this, what scares me about this particular section is where it makes it illegal to transfer juveniles out of state. Now, what I am seeing in Nebraska is that we don't have enough placement for at-risk juveniles who actually need both a staff secure location and a normalized school experience. So the in-state options that we have are often full, or they decline to accept placement based on prior behaviors. And what that means is the juvenile detention gets extended because we've got no place for the child. In my perspective, from what I've seen, DCYC and some of the other centers, they're supposed to be short-term, but DCYC in Omaha, they're up to like a 90-day standard minimum. Used to be like 30 days. So I am concerned that that provision, while perhaps well-meaning, I'm not sure I know what's behind it, is going to actually be worse for kids, at least from an educational perspective. So I'm watching that piece very carefully. From LB, let's see, I'm going to move on to the next one if the screen can advance. LB 632. This prohibits suspension of students in pre-K through second grade in a school in the city of a metropolitan class. That means OPS, because that's the only one. The most common question I hear about this is anybody actually suspending PK2 kids? And the answer is yes, a lot. That's why the bill is directed to it. What we see is littles that are acting out, but that, from my perspective as an education lawyer, is communication, and these kids don't have the skills to communicate correctly. So what this bill is seeking to do is say, let's do instruction, intervention, supports. I mean, it doesn't say it in the bill, but that's going to be the necessary reaction of education is, let's do this before we arrest 7-year-olds for ostensibly assaulting somebody, which does happen. The one thing I wanted to address is there's a couple bills that we've been talking about impacting cities of the metropolitan class. This is sort of an aside, but from my experience, that's a closed class issue. Well, there may be constitutional issues in any bill that says it impacts only cities of the metropolitan class. And that's because the definition now for a metropolitan class city is one that has its own retirement system. And there's only one in the whole state that does, and no others are allowed to have that. So effectively, it's a closed class. I don't know that anybody would ever challenge this legislation or this or anything else based on that. But I know Bree was saying, gee, it would be nice if we could have this in other places. I think a closed class issue is lurking underneath these bills. I'm going to move on. LB 774. The reason this bill I think is important is because what it does is it gives children a little bit more due process. It's almost a cleanup bill. It adds time frames for discipline before they be referred or, the system. It clarifies definitions. It gives them a right to a hearing by a neutral party, not the person that's hired by the superintendent that's asking to expel them for whatever they have done that probably has also got them in the system. This bill actually passed last year, but it was vetoed by the governor within, I think, 2 days of the legislative session ending. So there was no opportunity to override the governor's veto. And the governor's objection related largely to an OPS concern about the definition of intent. And that definition has been removed from this bill. So I'm not, what this really does is try ostensibly that we talk about the school to prison pipeline. We talk about making sure that we have fair and equitable procedures for students that are getting disciplined before they end up as juveniles, because some of our referrals come truancies all come from schools. Neglect it can be impacted by schools, and delinquency can also arise from the school context if the student has been, violating the discipline code, and that also results in a referral to law enforcement. I'm going to go to 881, which is changes relating to the Student Discipline Act and using physical contact. So this bill has been before the legislature a lot. It was Senator Groney introduced it like 4 times in a row, I think. And every time it's been defeated. The big challenge with this bill from the juvenile perspective is it permits harmful restraint and seclusion by any school employee, whether they're trained or not, no time limits on the restraint. And across the country, children who have been restrained, especially when they've put in a prone position, they've literally died. Um, the substantial opposition to the bill is due to the harm that it can bring and the disproportionality that restraint and seclusion have on children of color and children with disabilities. And those are largely the children that we also are seeing disproportionately impacted and in our system. So right now, there are a lot of amendments being introduced. I've been told that this is because it appears that they want to make this a priority bill of the Education Committee. I don't know that that's a true thing, but that is the assumption with regard to the lots of amendments that are being added to it. I think that this is a real challenge, just what is right and what is wrong for our kids. I think I heard Dennis and Bree echo, our children, no young adult, disabled or not, has their brain intact until they're about 25. And when we put hands on children, especially children who are disabled, we are likely going to find more assaults, more issues that are going to land those children in the system. And my goal as Education Rights Council is to keep them out of the system. I'm also supposed to talk about, and this says on my list, funding as a topic. I don't see that on this list. So I guess the only thing I'm going to keep a time frame is we've got voucher bills, special ed funding bills, foundation funding out there, option enrollment funding. All of them impact juveniles, like in terms of choice of education. None of them really address the actual cost of improving education for kids in detention. I think education for kids in detention is a crucial thing that we need to address. The laws on the books actually aren't being followed, and we also don't put a lot of money for it. And yet we want our children, we don't want recidivism, but we aren't educating our kids well at DCYC, certainly not at DCC. And it's a problem because they do have specific educational rights that aren't being met. Okay, finally, LB 414. This changes provisions related to the enrollment option program. For those of you who are unaware, the legislature a long time ago enacted laws that say, look, if you as a parent feel that a different district would serve you better, even though you live in District A, you want your kids to go to District B, here's a process, here's a program. What you can do is you can choose to have your children go, you apply, the district has a period of time to select and say yes or no. And that way, grandma's in Seward and you're in Lincoln, maybe they can go to Seward Public Schools and go home to grandma at the end of the day. The problem is that Nebraska's law effectively discriminates on its face with children who have disabilities because it lets it say any program is full, and a program, special education is defined as a program. So since the majority of juveniles in our system end up having disabilities like anxiety, depression, PTSD, ODD, ADHD, you name it, it has a huge negative impact on a juvenile's ability to get a fresh start. So one of the things that we try to do is work with kids while they're in the system, because of course every judge is going to say, and go to school and get your education as part of your exiting the system. Many children can move, but if the child has a disability, no district right now, there are a few. The vast majority of districts simply say we're full to a kid with disabilities. So the changes in this bill would require some accountability by publishing some standards and doing individual reviews, because places like the Office for Civil Rights and different circuit courts in different states that have had similar bills to this have found them unconstitutional. Okay. That's my presentation, and I'm looking to see, I see there's a question in the chat about this. There's 2 questions. One is not placing our kids out of state. What about our kids in the Panhandle of Wyoming? Is it so much closer to Omaha? I think that's a really, really good point, that Senator McKinney's bill about saying, hey, You cannot go out of state and place somebody unless they have a medical emergency or a mental health emergency, and I'm not sure those are defined well, would negatively impact the rural areas, because you're right. We need to, our state needs to either pony up and fund some more placement and better education for our kids, or we're going to have to take advantage of outstate, or we're going to be hurting our kids. And I'm not sure that, I think Joan is right. I doubt that was looked at. The other question that's out there is, so does it mean that children no longer can enlist in ROP placements through probation or department? And I think that you're still talking about the that part of LB 339 for McKinney. And if that's what you're talking about, I don't know the answer to that. I think it's a court appointment. So if it takes the court order, it very well could apply to those as well.
All right. Thank you, Elizabeth. You are a wealth of knowledge, and we really appreciate your input. I will note before we turn it over to our next presenter that we are inching towards the 1 o'clock hour. So for folks who need to log off, just a reminder that this webinar will be posted on our YouTube page if you want to finish it up later. So next we have Sarah Helvey. Sarah is a staff attorney and the director of the Child Welfare Program with Nebraska Appleseed. Thanks for being here, Sarah.
Thank you. It's always an honor to present on this. I'm going to go really fast for those that have to get off at the top of the hour. And I know you would probably rather hear from HHS and probation than me. But I want to mention several child welfare bills addressing kids and families in the foster care system. And the first one I want to mention is LB 14. I won't go all the way through it because I think I've mentioned it. For sure, I mentioned it last year and previous to that. It's a bill that is intended to expand the Bridge to Independence program to include a subset of the juvenile justice population, specifically those who need a supportive bridge to independence because they don't have a home to return to and may face homelessness. This was previously introduced by Senator Patty Pansing Brooks, but she term limited out. So it was introduced this year by Senator George Duncan. He's a new senator from Lincoln. He's one of us. I think he was a public defender. So he's really energized about this bill. And it's something that many advocates and young people have wanted for a number of years. So we hope to see it move forward this year. But there's a whole process and standards that I'd be happy to talk about later. But I have before, so I'll move forward to another bill that I've mentioned previously. It's LB 42 this year. It was LB 1000 last year. It's a bill that would narrow the definition of neglect in Nebraska. It's introduced by Senator Ben Hansen, who now is the chair of the Health and Human Services Committee. But all of the bills I'm mentioning this year were referenced to the Judiciary Committee, which is a little bit different. So again, this bill would narrow the definition of neglect. We have a very broad definition of neglect in Nebraska, and it would specifically to protect the ability of children to engage in reasonable childhood independence activities without the parents being called into the hotline or brought into the child welfare system for things like walking to school, playing outdoors, being unattended in a car when it's not too hot or too cold, those type of things. There's a broad group of allies that kind of across the spectrum that had been involved in a coalition to bring this bill forward. But again, I know for all the lawyers out there, it does amend 43-247 and 43-292. And so I know that feels significant. But again, there's my argument would be a lot of outdated language there and a really broad definition, for example, that permits criminal neglect for knowingly permitting a child to be placed in a situation that endangers their mental health, for example. And that's something that I think a lot of, particularly parents of adolescents, may feel that there's a lot of situations that could meet that definition. So it tweaks it a little bit there. And again, reference to judiciary but not yet scheduled for a hearing. The next bill is a new one that was introduced this year. It's LB 271. It was introduced by Senator Terrell McKinney. It came out of an interim study that he had looking at systemic racism and disproportionality in the child welfare system and a series of town halls he had on that. Was a lot of great feedback. There's more work to be done on the race equity issues, but this one is looking at universal mandatory reporting because that is something that we heard really significantly from the community. Nebraska is one of only 18 states that requires all individuals that that have any cause to believe abuse or neglect has occurred, requires them to report that subject to criminal sanctions. And this bill would only require certain professionals to report, including medical professionals, mental health professionals, school employees, social workers, childcare providers, law enforcement, clergy, and the inspector general. Again, any individual still may report, but they just would not be subject to failure to criminal sanctions for failure to do so. Importantly, the bill also changes the standard for mandatory reporters from any reasonable cause to believe to observation or knowledge of conditions or circumstances which reasonably would result from or in child abuse or neglect. And then the bill also requires mandatory training of mandatory reporters within the first 90 days of employment. The bill is specific that that training is to address how to identify abuse and neglect reporting, trauma-informed responses, implicit bias, cultural competency, and race-conscious reporting, as well as alternatives to reporting, including available community resources and prevention services. And we're really lucky in Nebraska to have a robust community response. And so really training reporters on when it's an appropriate or required or appropriate referral to the hotline and when it may be a more appropriate referral to 211 or community response. And it also requires HHS to create a free and publicly available online training in consultation with those community groups and people with expertise in implicit bias and culturally diverse family systems. The intent there is so that all private employers don't have to do their own training if they don't want to. They can direct their employees to the free online training from HHS. And then finally, I want to just mention, without going into it, that the bill as introduced has an exception for reporting in certain circumstances, but we have gotten a lot of feedback from partners with concerns on that. And so we expect there will be a revision on that aspect of the bill, but we don't have that confirmed yet from the senator. So I don't want to get out ahead of that. But there has been a lot of feedback on that exception. So as a result of that, I'm just not going to go through it today, also given our time. And then two more to mention even more quickly. LB 306 is the Youth and Care Bill of Rights. This was previously introduced and reintroduced this year again by Senator Megan Hunt. There was a lot of youth input on this bill. It incorporates that youth input, and it specifically goes through a list of rights that young people in foster care have. It does not include juvenile justice. That was an amendment in previous years due to feedback about the rights of parents in juvenile justice cases, and also has some provisions around notice to young people of their rights, letting them know about a grievance process and what they can do if they feel their rights have been violated. And then lastly, I just wanted to mention LB 159. It's a bill regarding young people in foster care and access to higher education. It was introduced by Senator Mike McDonnell, and it would provide grants to the Coordinating Commission for Post-Secondary Ed for young people in foster care at age 14 or older to receive grants for up to 3 years for a 2-year degree, up to 5 years for a 4-year degree, to include not just, there are several programs for tuition, but often the barrier is the fees, room and board, books, and required supplies. So these grants would include the full cost of not just tuition for young people to access post-secondary ed. It even took longer than I thought, so I'm going to conclude there. But if there's any questions, you can put them in the chat. I'll try to answer them, or you can email me directly. Thank you.
Thank you, Sarah. I will now send it to our next presenter, Jeannie Bradner, who is a Deputy Administrator with the Nebraska Administrative Office of the Courts and Probation. Welcome.
Thank you, Teresa. Good afternoon, everyone. And I know we're over time. I apologize. I know we're racing through these. This year, there's a lot of activity in the legislature. So again, thanks to Judge Stevens for setting the precedents here as a judicial branch employee. I'm certainly not taking any position on the bills, but simply just providing information and, with everyone can do their own due diligence and look at bills and understand potential impacts. And again, a lot of this, we don't know the ins and outs or the details, and we're just trying to sort it out as we move forward too. So I'll start with the first one, LB 81. This bill already has had its public hearing on last Friday on February 3rd. This is adding an additional county court judge in Judicial District 9, which is Hall and Buffalo counties. The number of juvenile cases in that area has skyrocketed in the last few years. And again, with some provisions, some specific provisions for how a separate juvenile court is created. I think the ease of getting a county court judge in there to help with that flow right now, there's been judges from other jurisdictions that have been helping out there. So that certainly is out there. And I don't believe that has been any action after that hearing on Friday yet. The next one is LB 240, introduced by Senator Wayne. This is a bill that would allow for modification of disposition orders. I wish Judge Turnbull was still on the bench. He used to talk about this a lot in terms of those in the juvenile court capacity not having the ability to modify a disposition and or conditions after they were pronounced by the court. And so this is allowing for, if all parties stipulate to a modification, and the juvenile also has to either have consulted or waived their right to counsel. So I know that there are lots of differing opinions on that. But again, under a rehabilitative model and code, we would want, if the juvenile and parties are agreeing to have some additional terms or modifications or time to do treatment or things like that, that may be potentially a benefit to the process. LB 435. This, and I apologize, 240 is set for hearing on the 16th. I think that just came out earlier today, as well as the next bill 435 is also set for hearing on February the 16th. This is a bill introduced by Senator Geist to provide court appointment of parental advisors in juvenile justice proceedings. This one reads a little bit like a CASA or GAL type guidance to juvenile court proceedings and how they might move forward, discussing possible dispositions and outcomes, available options to youth and families. So maybe a little bit of a legal aspect there. It does require the positions to be housed under the Supreme Court or the Administrative Office of Probation. I can't remember the exact wording on that. So clearly there's maybe some potential for conflict there, but that is, again, conversations that are likely occurring with Senator Geist. Moving on, LB 473, again, a bill proposed by Senator Geist. This one creates a grant program to, and maybe someone used the term earlier, a pilot, offers a pilot to operate what is termed a new term, a safe and secure treatment center. Usually when we hear treatment, we think about behavioral health. This one is housed under the Nebraska Crime Commission, and right now the Crime Commission oversees jails and detention. I will call the attention again, this one does have a hearing set for the 15th of February, and a very important impact on this one. This is specific for 3B and 3C filing, so youth that meet those thresholds. So safe and secure treatment center for those youth. Looks like we're a little bit out of number order here, but I will just go ahead and keep moving as it's proposed here. LB 687 looks at creating, again, this is one that's been proposed several years. The Nebraska Integrated Juvenile Data Governing Body and Integrated Data System Information Sharing. Again, there's been a lot of look at this and study. This one is also scheduled for February the 16th, I believe. So similar conversation around that will occur that has in the past about, yes, I think there's a lot of people that desire and want this. The complexities of systems talking to each other and then getting through the hurdles of the information sharing, I think is the bulk of the work that has really stalled that in the past. LB 708 is a similar information sharing, Senator Arch. And this is a result of a legislative resolution. And so there has been several meetings prior to the session starting around this, and this is specific to educational data. So the Office of Probation, State Court Administrator, Department of Education, DHHS, have been meeting to talk about what the bill proposes is to bring in a contractor to help facilitate some of those discussions and look at, as I mentioned before, some of the complexities of whether it's federal law around education data, FERPA, whether it's HIPAA, or whether it's our own state laws, and then also, again, the complexities of information, who owns the data, how does it flow, those types of things. So that is there as well. And then 479, which I believe is my last one here. This is introduced by Senator Wayne. This bill looks to transfer the Office of Probation Administration to its own independent agency, but make it under the executive branch instead of the judicial branch. Again, not going to take any position on that, but clearly there would be some differences of probation not being under the judiciary. It is allowed, my understanding that it's allowed in our Nebraska Constitution to be housed in either branch, but there would certainly be a pause on things that are set up as they are currently that would need to be restructured if moved to an independent executive branch. As written, all employees would transfer with the exception of the probation administrator, who would be then a governor appointed position. That's all I got for you.
Hey, thank you so much, Jeannie. That was a great, succinct explanation of the bills. Last, but certainly not least, we have Laura Opfer, who is the Deputy Director of Policy and Legislative Services with DHHS's Division of Children and Family Services. Thank you for sticking around, Laura.
Good afternoon. So just a couple updates on my end, since everybody else did such a good job of covering the bills. But I did want to note on LB 42, the department has for the last couple years been undergoing a fidelity review and reliability review for some of our structured decision-making tools. And so we have some in-focus changes that are awaiting updates, and we should be seeing those roll out hopefully later this year or early next year. And those do not conflict with 42. And so I just wanted to share with everybody that you should be hearing some updates about that. As most of you know, our system updates are a little bit slow going. So it just takes some time and planning for us to implement the new tools or the updates to the tools. And then Jeannie covered 708 well, but I did just want to note some items of importance for us. So this requires NDE to contract with an independent consultant, and some of the things that they will be looking at along with data sharing are also developing a uniform approach for the transfer of educational credits. So I just wanted to highlight that because that is a barrier that we see, especially for our kids in children and family services who may move from home to home and in different districts. And for our kids at the YRTCs, certainly, we really want to put our heads together and figure out a way as a system to help make sure our kids get credit for what they've done and that we're not duplicating their efforts when they do move. So that is all that I had as far as updates. Thank you again. I know we're over time, so I wanted to keep that brief.
Thank you so much. And thank you all for joining today. I know that we did have a question in the chat about hearing dates for some of the legislation, and CIP does have a legislative tracking sheet that we can send out to all participants so that you can see which ones we're following, so you can follow them as well. For attorneys, the CLE number is on the screen, and we will ask that you maybe stay tuned later in the year around June, where we will have a follow-up presentation for the legislative session. And I just finally, before we hit 1:15, want to thank all of the presenters, one for just being here and sharing your knowledge, but also for sticking with us a little over the 1 o'clock hour. We always appreciate your insight, your knowledge, and your experience, and we look forward to future webinars. So thank you.